Parles-tu français? Hablas español? Parli italiano? If you've used Babbel, you would. Babbel's conversation-based techniques teaches you useful words and phrases to get you speaking quickly about the things you actually talk about in the real world. With lessons handcrafted by over 200 language experts and voiced by real native speakers, Babbel is like having a private tutor in your pocket. Start speaking with Babbel today. Get up to 55% off your Babbel subscription right now at babbel.com/Wondery. Spelled BABBEL.com/Wondery. Rules and restrictions may apply.
And Trump's argument is not, oh, we did fire you for cause, you were inefficient, whatever. His argument is that the law is unconstitutional because you can't prevent the president from firing heads of executive branch agencies.
Welcome to Law and Chaos. The Justice Department finally got someone to file the paperwork to dismiss the case against New York Mayor Eric Adams, and the Trump administration is bigfooting into the Supreme Court and begging the conservative justices to remind everyone that the laws don't actually apply to him. We've got a lot to cover, so let's get after it. Hey guys, I'm Liz Dye, and with me as always is Andrew Torres. Andrew, how are you?
Hey Liz, well, I have electricity at my house, so how are you?
You guys may infer from that and from the excellent microphone quality here that I do not have electricity at my house. Have not had electricity at my house for upwards of 30 hours now. Not great. There was a big windstorm on the East Coast, and that sucked. So I am recording from inside a closet surrounded by clothes that are not mine in a house that is not mine in an undisclosed location. I apologize for the audio quality. BGE says, for sure, midnight, I will have power. We shall see.
Nor wind, nor rain, nor power outages will stop us from bringing you Law and Chaos.
Correct. So for our main stories, we will follow up on the Thursday Night Massacre at the Justice Department. And then we're going to talk about the first Trump case to beach itself on the shadow docket at the Supreme Court. That case is Dellinger v. Bessent.
Yeah, and that's going to be procedural geekery, maybe the best kind of geekery. But look, it is critically important for the future of democracy, right? What happens in that case, in my view, is literally the difference between the courts serving as, some impediment to Trump's lawlessness or none at all. So you will want to stick around for that story.
Okay, well, there is a lot of crazy shit going down. I suspect that's going to be the case for a good long time to come. But let's talk about docket alerts. Yeah, maybe we will one day get a bumper. I was thinking something kind of like, the I'm the Map song from Dora the Explorer. I'm the map, I'm the map.
As long as it's not the Wonder Pets, I'm here for it.
Miffy, a cute little bunny. That's for parents who, that's for all the parents
save
out there.
Him, save the hamster. Okay, anyway.
All right, so let's start with some good news. On Thursday, Judge Amir Ali of the federal court in D.C. enjoined the Department of State, the Office of Management and Budget, and USAID from operationalizing Trump's January 20th executive order entitled Reevaluating and Realigning United States Foreign Aid, by which he meant freezing it and not letting any of it go out. So the defendants are currently barred from suspending, pausing, or otherwise preventing the obligation or disbursement of appropriated foreign assistance funds in connection with any contracts, grants, cooperative agreements, loans, or other federal foreign assistance award that was in existence as of January 19th, 2025, or issuing, implementing, enforcing, or otherwise giving effect to terminations, suspensions, or stop work orders in connection with any contracts, grants, cooperative agreements, loans, or other federal foreign assistance award that was in existence as of January 19th, 2025. All right, so you can't just cut everything across the board. You can still, you being the Trump administration, can still cancel foreign aid grants pursuant to the terms of the original contracts, and they are certainly doing that. It also would appear that they're flagrantly violating this order. There's new filings tonight that are just horrific about all of these USAID workers who are stranded. But long story short, they cannot cut all foreign aid across the board.
Right. So, like every other court to examine this issue, Judge Ali had zero difficulty reaching the conclusion that an executive order purporting to abrogate contracts and, cancel congressional allocations by fiat was illegal, unconstitutional, because it is. And this was a very measured, dispassionate opinion, right? But it does strongly hint at the flimsiness of the Trump administration's case, right? So the order says that at the hearing, quote, the government rightly highlighted the importance of respecting the president's Article 2 power, while also recognizing that the harms plaintiffs described may well be irreparable. So, if the government's main position is, it makes the president sad not to have his orders obeyed, and you should let him break the law and, cause all these people to lose their jobs because you blew up their contract. That's a pretty good sign that you're going to lose in front of Judge Ali, right? But I also want to flag one particular passage that highlights something we talked about in our written post at lawandchaospod.com yesterday. And that's the delta between the president's executive orders and the stuff that the government, right, his subordinates do to carry those orders out, right? So Judge Ali said, the court does not find it appropriate or necessary to enjoin the president or the executive order itself. Given the breadth of the relief initially sought by plaintiffs, the court also makes it clear that it does not enjoin the president's or Secretary of State's statements of purpose or policy, nor does the court enjoin any aspect of the government's ability to conduct a comprehensive internal review of government programs. While plaintiffs have made the showing required for a temporary injunction, such relief would not be adequately tailored to the showing made at this stage. So, a lot there.
Right. The government has taken the position that the courts cannot adjudicate an executive order because it's not a final agency action. And so the courts are kind of neatly sidestepping that issue for the time being. They're saying, basically, look, say any dumb thing you want, Mr. President, but you cannot operationalize that dumb thing because the operationalization of it would violate the law.
Right. And that highlights something that you and I have seen, which is the government basically trying to have it both ways, right? A bunch of times now. They want the agencies to do the illegal stuff that Trump orders them to do, but they don't want that order to be in a format that can be challenged in the courts. So, yeah, Trump is barfing out executive orders to cut all federal disbursements and, particularly any money allocated by Congress under the Biden Infrastructure and Inflation Reduction Acts. Then the Office of Management and Budget put out implementing memos telling the agencies how to do that. Then the states and the grantees sued to block the implementation of those executive orders. And then in response, the Office of Management and Budget rescinds the memo to try and moot the cases, right? As you pointed out, delightful White House press secretary Carolyn Leavitt tweets out that the memo is gone, only as a litigation strategy, but that the executive orders will remain and everyone still has to follow them, which was just, hilariously inept. But even aside from that kind of own goal, the courts weren't going to issue relief here anyway, right? Because as Judge Sean McConnell in Rhode Island said, I'm not enjoining the OMB memo or the executive order. I'm enjoining the illegal conduct, right? So however you call it, withdrawing the memo is irrelevant.
Right. And we saw the exact same thing in that order from Judge Brandon Herson in Maryland this weekend when he enjoined the government from enforcing the executive order defunding hospitals if they provide gender-affirming care to anyone under 19, because there too, right, DHS put out and later retracted a memo telling grant recipients that they were in danger of having all of their federal funding cut.
Yeah, and, to be fair, DHS says it retracted the memo. Like, you and I tried to track that down to link in the piece. DHS presented absolutely no evidence of any such rescission, right? They just stated it in a pleading. But whatever. The point is that the government ran the same play in both cases. It's got one playbook. They said, Judge, you can't enjoin an executive order, and now there's no memo to enjoin, so we're cool, right? And courts uniformly have been like, no, we're not cool. Even if I take you, Trump administration, at your word that you rescinded the memo, trans kids are still losing their medical care because of the executive order. So I'm enjoining you from enforcing that executive order and taking away the funding. And then a day later, Judge Lauren King in Washington State issued almost the same order as Judge Herson in Maryland. It actually went, it enjoined Section 4A. It prevented the administration from defunding or clawing back grants that went to hospitals or schools that offered gender-affirming care. It also enjoined Section 8 of that executive order, which instructed the Department of Justice to define gender-affirming care as female genital mutilation and then figure out how to investigate and prosecute doctors who provide gender-affirming care under the criminal law preventing female genital mutilation. Like, this is horrible stuff. And we talked about all of this in detail in the written post. We'll link it in the show notes. But I think the bottom line is that Judge King really picked up what Judge Herson was putting down in terms of a judicial strategy to combat, a full court press by the Trump administration with these illegal orders.
Yeah, and we're also, speaking of transgender rights, watching a case called Talbot v. Trump, which involves service members suing to block implementation of an order kicking all transgender people out of the military. And once again, the government is trying to stay in that liminal space between Trump's executive order, which he just, says his bigoted thing and says make it so, and the actual implementation. They want to be in this non-place. They want to be Schrodinger's cat for as long as possible. So they're arguing that service members have not yet been separated. They're not yet being denied health care, and so there is no injury. But that's not entirely true, since the military did change the assignments of some trans service members before getting sued. And B, Secretary of Defense Pete Hegseth is very hot to implement these orders. He's getting all ready to do it after he gets through with Leg Day and embarrassing us overseas. That's only partly a joke, right? Like, they have plans to do it. They just have not operationalized those plans. So the Secretary of Defense is like, well, we're not there yet, so how about we don't do that? So this case is before Judge Ana Reyes in the U.S. District Court in D.C. We actually listened to a couple of hearings from her last week, and they were both really interesting. The first was in this case.
Yeah, and what struck me about Judge Reyes was she came prepared. She had read all of the pleadings. She had read all of the underlying cases. And she did this thing that even when you're on the losing side, I mean, I don't know what it's like to be on the Trump losing side, right? Where your arguments are pretextual and terrible. But even if I'm, if the judge says I'm leaning against you, I'd rather have the judge say, I'm leaning against you, counselor. I would like for you to answer the following 8 questions. And she did. She basically articulated, I expect you to come back here at the TRO hearing, and I want to know your opinions on these cases. And I want to know this argument. And the government's argument was essentially a standing argument. And Judge Reyes was like, right. Assume I rule against you on standing, then what do you got? And the government was like, well, then we would have this standing argument. And Judge Reyes was like, I get it. Anything else? And look, you either have it or you don't, but it's always good when a judge tells you, this is what I'm looking for, this is what I want you to answer. And she was great.
Right. And she did the same thing for the plaintiffs here. She said, look, plaintiffs, I'm seeing some missing spots in your argument. You've missed some steps here. So when you come back here, fill in the blanks. And that's, as you said, that's really good. Okay, so that was great. And so was the other hearing, although sort of in a different way. That one involved the inspectors general Trump fired on January 25th. The law says that the president has to give Congress 30 days notice and an explanation if he fires inspectors general, which of course he can do. Now, firing the IGs, that is the people whose job is to monitor federal agencies, is a naked act of corruption. It's a screaming neon sign that says hey, we're going to do a lot of crimes and we don't want anyone around here who can call us out on them. So you guys got to go. But also waiting 3 whole weeks to file this lawsuit as the IGs did, and then racing into the court demanding emergency relief is not a great look. So the Trump administration can suck. And they also, the inspectors general, can have screwed the pooch here. 2 things can be true at once. So the inspectors general are represented by Seth Waxman. He was the solicitor general under Barack Obama. And Judge Reyes tore him a new one at this hearing on Friday. She said, basically, how dare you come in here with this demand for emergency relief when you know everyone in this courthouse is working overtime, by which she meant every judge in D.C. is drowning under these Trump cases. She did not say it because it didn't have to be said. Everybody knew it to be true. So Judge Reyes gave Waxman a choice. She said he could drop the request for a temporary restraining order and go for a preliminary injunction, which gets briefed on a much less expedited schedule. It's not an emergency form of relief. Or Waxman could continue with the motion for a TRO, and Judge Reyes would allow the government to seek Rule 11 sanctions without notice.
That is strong language. And again, I'm glad we're covering both of these cases, right? Because, Waxman is on our side. He's challenging the Trump administration here. But at the same time, Liz, as you point out, Seth Waxman, you're the Solicitor General. That means you represent the administration in Supreme Court arguments, right? He has argued more at the Supreme Court than all but a dozen people in this country, right? He knows damn well that he came into court without having dotted his I's and crossed his T's. Now let me explain that threat. We've talked about sanctions on the air before. Rule 11 is the classic vehicle in which a party challenges a pleading entered in by the other party, right? It says a lawyer may not sign a frivolous pleading, right? One that is not supported by existing law or a non-frivolous basis for an extension or reversal of the law, right? And that's a strong threat. And the way in which you get Rule 11 sanctions is you tell the other side, hey, we're going to move for Rule 11 sanctions unless you pull this pleading. And then they have 21 days to pull the pleading. If they don't, you can go to court and say, hey, we even tried to let them pull this pleading, but you got to give them that 3-week safe harbor period. When a judge says, I will allow the other side to immediately move for Rule 11 sanctions, she's basically saying, I can't believe you signed your name to this. I think this is potentially frivolous, and I'm going to let him tee it up right away. And that I would never want a judge to say that to me.
Yeah, and on the way out, Judge Reyes said to Waxman, hey, I would actually be issuing a show cause order as to why you should not be held in contempt if we weren't so busy. So good luck, sir.
Yeah.
Okay, it's Monday, so it's time for us to thank our terrific supporters who financially support the show over at lawandchaospod.com. That's on Substack, or on Patreon at patreon.com/lawandchaospod. So from Substack, thank you to our new subscribers this week: Ludix, Stephen Nolan, Jack Kaplan, Chrissy B, Sharon Lee, Kyle W, Jacob Jernigan, and Will Bate.
And a big thank you to our Patreon supporters, patreon.com/lawandchaospod. Those are Dave L., Melody Woodward, Anthony Valdez, Plain Jane, Andre Bouchard, Frustoso Gonzalez, Jimmy Naughton, D., George Pagel, Skips, Rian Hibner, Zach Maria, and Sean Kellogg. And we will be back to talk about the continuing fallout at the Department of Justice after this brief ad break. Unless, of course, you are one of those aforementioned subscribers, at which point no ads for you ever.
And we're back. Okay, let's follow up on the Thursday Night Massacre. In our last episode, we told you about the staggering corruption at Donald Trump's Department of Justice. To recap, last week, Acting Deputy Attorney General Emil Bove, who had previously been one of Trump's personal criminal lawyers, instructed the interim head of the U.S. Attorney's Office in the Southern District of New York, Danielle Sassoon, to drop the criminal charges against New York City Mayor Eric Adams.
Yeah, this was openly, nakedly craven, right? Bove's letter explicitly noted that the decision to drop the charges against Adams, right, those are bribery and corruption charges, was not based on the merits of the case. Quote, the Justice Department has reached this conclusion without assessing the strength of the evidence or the legal theories on which the case is based, which is, pretty big admission. Instead, Bove's decision was based on Adams's willingness to break New York City's sanctuary city laws, turn information over to ICE, Immigration and Customs Enforcement, and otherwise, cooperate with the Trump administration's immigration policies. And that's not just something Adams isn't required to do, wasn't elected to do, is at odds with the city of New York. That's something he is not legally allowed to do.
Yeah, New York City passed a sanctuary law in 2014, which bars him from doing things like he did last week by allowing ICE to set up shop at Rikers Island again, right? This is clearly not what his constituents wanted him to do, and he wouldn't do it. He said he wouldn't do it during Trump's election. He said he wasn't going to do it, and he's had a sudden change of heart.
Yeah, and again, as documentary evidence, right there in Bove's letter, urging dismissal, it has an express condition of dropping the charges against Mayor Adams. Quote, "This matter shall be reviewed by the confirmed U.S. attorney in the Southern District of New York."
Right, that's going to be Jay Clayton. And we talked about this in sort of greater detail on the show. Jay Clayton was never a prosecutor. He was the head of SEC, the Securities and Exchange Commission, during the first Trump administration. And when Bill Barr tried to Saturday Night Massacre the Southern District of New York last time because his Attorney General Jeffrey Berman refused to back off and drop the case against Rudy Giuliani, Bill Barr tried to fire him and get Jay Clayton in there. But Berman was so loud about it that Barr basically couldn't get away with it, and Berman's deputy, Audrey Strauss, took over. But here Clayton is back. I mean, it's so poetic that Clayton, who was involved in this mess the first time, he's here the second time. Like, it's so clear that he's supposed to be the hatchet man in, I think it was 2019, and damn if they don't want him for the same job now.
Yeah. Well, anyway, Clayton is going to get to review the matter, quote, "following the November 2025 mayoral election based on the consideration of all relevant factors."
Right, because if Adams has lost the election, then he's of no use to Trump, and they can charge him again. In fact,
Right.
as Danielle Sassoon said in her letter saying she wasn't going to do it, she said, "I'm ready to go to a new grand jury and secure a superseding indictment that adds obstruction charges and proves that Adams destroyed evidence and got other people to destroy evidence." So, that evidence is there. They're just not going to operationalize it, since that's the word of the day, as long as Adams is of use to them.
Right. And look, this is all terrible. But one positive thing that's coming out is that lawyers are now openly discussing the dynamics of exactly how this quid pro quo works, right? And I don't think the Trump administration expected that. So in particular, we described how this was both a carrot and a stick, right? Like, the benefit to Adams is they're dropping the case, but they're dropping the case without prejudice. So if Adams doesn't play ball, they can just indict him again.
Right. So Sassoon, who, by the way, was handpicked by Trump to run the Southern District of New York while Clayton was getting confirmed, refused to do it. She resigned rather than drop the case under those conditions. And after our episode aired, the resignations continued at the Department of Justice. Both of Sassoon's deputies resigned, including the lead line prosecutor, whose name was Hagen Scotten. His resignation letter is great. We'll quote it here. He says, "No system of ordered liberty can allow the government to use the carrot of dismissing charges or the stick of threatening to bring them again, to induce an elected official to support its policy objective. Any assistant U.S. attorney would know that our laws and traditions do not allow using the prosecutorial power to influence other citizens, much less elected officials in this way. If no lawyer within earshot of the president is willing to give him that advice, then I expect you will eventually find someone who is enough of a fool or enough of a coward to file your motion, but it was never going to be me."
Bravo.
So by midday on Friday, a total of 7 senior Justice Department officials had resigned in protest, including all of the prosecutors who worked the Adams case. That's Scotten and also Celia V. Cohen, Andrew Rohrbach, and Derek Winstrom, all of whom immediately filed notices of withdrawal with the court.
Right. And so that led Bove to drag every member of the public integrity section at the Department of Justice into a closed conference room and threatened to fire them one by one until someone was willing to sign off on the dismissal. I mean, he's literally threatening to execute the hostages here. That someone turned out to be Edward Sullivan, who is senior litigation counsel at Public Integrity Section, which is abbreviated PIN, right? And I want to be very clear here on the show that every report that you and I have received, that is both public and private, is that Sullivan basically fell on his sword here, right? He is a long-standing civil servant. He's been a prosecutor for decades. He's been through a lot. And his view, as far as we can tell, is that, okay, the point had been made in terms of drawing public attention, right? Nothing further was to be gained by more people quitting, right, or getting fired. And he didn't want to see Bove fire a bunch of talented career prosecutors in the public integrity section, right? Like, that would almost certainly hurt the cause of justice overall. So he said, fine, I'm going to step forward. I'm going to do it.
Yeah, I just want to interrupt and point one thing out here that other people have said as well, which is that Bove did not need anyone to sign this, right? He could have signed it himself. And what he did here was to impose this loyalty test and impose it at the barrel of a gun. And look, lots of people have criticized Sullivan, but I think Sullivan's point is if they are doing this to try and get rid of you, don't let them do it, right? You've made your point. This case was already front page news for multiple news cycles, right? You got all the juice you're going to get out of this. So I'm going to put my name on this so they don't have an excuse to get rid of us all. But note that none of those people had to sign it. Bove could have signed it.
Yeah, and further to your point, Sullivan did sign. He was joined by Antoinette Bacon, who is acting head of the criminal division, and about whom, how should we say this? I guess I'll just say we do not have any reports of good motives.
Right. And Bove, I mean, he did sign it in the end. Okay, we're going to break down that government filing after this ad break. Okay, we're back. So let's talk about what the Justice Department actually filed in the Adams case. It is a notice of nolle prosequi, colloquially known as nol pros. That's Latin for do not wish to prosecute. And it's pretty obvious what it says. The government is no longer going to prosecute this case for now. That's what it means in every other case that it's filed, and that's what it means here. It was filed pursuant to Rule 48A of the Federal Rules of Criminal Procedure. That's what the Trump administration hauled out the last time around when Bill Barr ordered the case dropped against Michael Flynn, even though Flynn had already pled guilty and, in fact, reaffirmed his plea several times in open court.
Okay, this is my hobby horse, so let me unpack it a little bit.
Yes, it is.
At common law, 13th century Saxony stuff, prosecutors could just drop cases whenever they wanted. They didn't have to get permission from the court. And as you might imagine, that led to this potential for abuse, which is, suppose the prosecutor hates a particular defendant, right? You might even imagine it's well-intentioned hate, right? Like the prosecutor knows it's a bad guy, so they want to charge him, get him off the streets, but the investigation doesn't reveal sufficient evidence. And now you're on the eve of trial, and the government's like, man, if we go forward to trial right now, we're going to lose, and this is a bad guy. So what we're going to do is let's cut this guy loose right now, and then we'll re-indict him tomorrow. We'll keep the investigation going. We'll push off the trial for another couple of years. Like, eventually we'll find something, wash, rinse, repeat. And at some point, the defendant is going to say, look, stop jerking me around, right? Take me to trial or give up, but don't do this forever, right? And that situation of abuse is the paradigmatic case of Rule 48A. Rule 48A changed the common law rule from prosecutors can drop cases at any time to the government may, with leave of court, dismiss an indictment, information, or complaint. And that leave of court meant that the judge would have the opportunity to just get a view of the landscape and maybe hear evidence if required, which would, primarily come from the defendant, that there was the kind of prejudice that, I just described. But in the Flynn case, that got put to the test because it wasn't that the government was being too hard on Flynn, right? It's that it looked like a corrupt political payoff and there was going to be nobody in front of the court to argue that it was, right? Like the government wanted to drop the case, the defendant wanted the case dropped. That looked like the fix was in. So I wrote an amicus brief arguing that Rule 48A's leave of court allowed the judge in that case, that was Judge Emmett Sullivan, to inquire as to whether there was, in effect, a corrupt bargain between the government and the defendant. And long story short, the law is not settled by any means, right? That's why I had to write the brief. But I think there is a very good argument that the judge can do that kind of inquiry. And Judge Sullivan certainly seemed to think so. And ultimately, we didn't get to find out because Trump mooted the whole question by just pardoning Mike Flynn instead.
Yeah. So the Eric Adams case is before Judge Dale Ho of the Southern District of New York. He's another very good judge, although he's only been on the bench about a year. Judge Sullivan had been around for a long time, and he was widely respected on both sides of the aisle. So his actions were seen as not very political. I mean, by normal people, obviously, the Trump administration made a lot of noise about it.
Right.
I would expect that if Judge Ho does anything other than sign the government's permission slip, he will get hammered by Elon Musk and the MAGA loons. Anyway, as with Flynn, the government's no pros notice requires leave of court. And in terms of the options available, I want to quote from the amicus brief filed by Nick Akerman today as we're recording this. He's a former Southern District of New York prosecutor and a current attorney for the liberal watchdog group Common Cause. He writes, with the government agreeing with Mr. Adams to dismiss the indictment, no party before the court is representing the public interest. We respectfully ask the court to appoint a special counsel to advise the court in resolving this unfortunate matter.
Yeah, and I want to say for that part, that is, I mean, it doesn't come up that often, but it is standard procedure when you have a legal question where all of the sides are not represented by any of the current parties to the case. This is what Judge Sullivan did in the Flynn case, for example, though he called it a special amicus. But either way, right, the court was like, look, nobody's going to argue this unless I appoint somebody. So I'm going to have somebody come in from the outside and make the best arguments they can. That's a third party.
Okay. Akerman continues, most obviously, the court should deny the motion to dismiss. In addition, it may consider the following: allowing discovery of the Department of Justice with respect to its decision-making in the matter, directing Mr. Bove to appear in person to explain his position, sanctioning DOJ and or Mr. Bove personally for making improper and unethical demands on prosecutors in New York and Washington.
Yeah, and all of that are things the court can and should, and I hope does do.
Right, continuing. Akerman says the court may also consider appointing an independent special prosecutor to continue the prosecution of Mr. Adams in this court and ordering that the special prosecutor have access to grand jury materials and other evidence assembled by the SDNY.
Ooh, okay. I want to talk about that suggestion, but two things. So first, as we went to record, I want to also flag that two more former SDNY prosecutors, Carrie Dunn and Mark Pomerantz, also filed an amicus brief urging Judge Ho to reject this corrupt bargain. And look, I don't think they're going to be the last.
Right. Let me interrupt because the names Carrie Dunn and Mark Pomerantz may ring a bell for you guys. That's because those were the two private lawyers. They were very prominent lawyers, and they kind of left the private practice and came and worked on special assignment for Alvin Bragg when he was investigating Donald Trump. And they both quit loudly when Bragg, the first time around, didn't charge Trump, mostly with respect to his financial crimes. And then, and actually Pomerantz was sort of subpoenaed by Trump's legal team because Pomerantz had written this really scathing book about, what a wimp Bragg was for not bringing the prosecution, about the financial stuff. And in that book, Pomerantz kind of derided the Stormy Daniels charges. And so he was dragged into that matter. But here they are. They're very well-respected practitioners in New York. And they filed this amicus brief. There were other lawyers who put their names on it, but these lawyers, let's say they have a history with the president.
Yeah. And again, I think Judge Ho is going to hear from a lot more of these folks in the next few days. But I want to go back to Akerman's suggestion that the court appoint an independent special prosecutor, right? Because on its face, that sounds like a pretty good way around the problem that you have here that you didn't have in the Flynn case, right? Flynn had already pled guilty. So if the court rejected the effort to dismiss the case, all that was left was for Judge Sullivan to pronounce sentencing. In this case, who's going to prosecute Eric Adams if the government says, we don't want to? And it sounds amazing to think, the court could just hire somebody to prosecute him. And I want to tell you, it's not impossible for a court to do that, but I don't think there's any chance that that's going to happen. I just want to cut that off at the knees right here because, look, Akerman, for support for this proposition, cites to a 1987 Supreme Court decision. It's called Young versus United States. I will link to it in the show notes. You're a lawyer, law student, this is a fun case to read on so many levels, right? It involved counterfeit Louis Vuitton handbags and this undercover sting opera. It's amazing. It's fun. Read it. You'll enjoy it. But for purposes of the show, the point is that case, the Young case, involved contempt. And contempt is different, right? So under both the federal rules and longstanding common law, if a party engages in contempt of court in the courtroom, right, in the sight of the judge, and the judge, the judge says, "Stop talking, Mr. Torres," and this will surprise you, I keep talking anyway, then I can be summarily punished, right? I don't have to have notice. I don't have to have a hearing. I don't have to have trial. The judge could just say, "Mr. Torres, I told you to shut up. You didn't." And toss me in jail. But if the judge says, okay, we're adjourning for the day, and Mr. Torres, don't talk about this case on the Law and Chaos podcast, and then I go home and I do it anyway, that's an out-of-court contempt. And that requires notice and a hearing, and basically I get prosecuted like a normal criminal defendant, right? And so in Young, you probably see where this is going, the district court was dealing with an out-of-court contempt. And the court was worried that if it referred that contempt prosecution over to the U.S. Attorney's Office, they would just decline to prosecute. And so the court appointed its own prosecutors instead. Nice solution. There were procedural problems, like the prosecutors that the court appointed were connected to a civil case. But the important thing is that the Supreme Court said that courts do have the inherent power to appoint a private prosecutor. The court said, if the judiciary were completely dependent on the executive branch to redress direct affronts to its authority, it would be powerless to protect itself if that branch declined prosecution. And so, bottom line is, there's some good language in the case, but that's not the Supreme Court saying that courts can just appoint private prosecutors in ordinary criminal cases. It's not saying that, but I think it's fair to say that this is an open question at best.
Yeah, I'm gonna let you finish. But I really, please do not anybody who listens to the show hang your hopes on that. Right, that is not going to happen. And also, we got bigger fish to fry than Eric Adams. Right? I mean, I think that there are many interesting ways that this could go down. That is not one of them. I am very interested in the Louis Vuitton fake handbag case. That sounds cool and all, but no, that's not what's going to happen here.
I am glad you broke in to say that directly, because I do not want people to get that level. It just Judge Ho is not going to go out on that level of a constitutional limb. And look, I do want to push back a little bit, right? Okay, Eric Adams doesn't matter, but in my view, the degree to which the Trump administration gets away with leveraging Eric Adams means that they've proven that they can do it. They can run the same playbook with any compromised politician. And
that I agree with 100%.
Yeah, so let's talk about a concrete example here. Democratic Congressman Henry Cuellar of Texas was indicted by the Department of Justice on May 3rd, 2024 for taking $600,000 in bribes. Cuellar, he was already one of the most conservative Democrats in Congress. He'd been primaried from the left. Not a lot of people like this guy to begin with. So it is not a stretch in my view. Again, this is just my supposition, but I can imagine Trump repeating the Eric Adams playbook and going to Cuellar and saying, hey, we'll drop the charges against you without prejudice if you switch to the Republican Party and start voting for Trump's agenda. And then every time a bill comes up, he gets a call that says, oh, your friendly neighborhood prosecutor checking in, reminding you that we could refile those charges at any time. That's again, you as you've said, we use Banana Republic a lot on this show since Trump took office, but that's a movie parody.
Yeah. Okay. Before we leave this, I want to flag a couple of things. Mm-hmm. The first is the supposedly non-corrupt premise of this dismissal, right? The one that wasn't we came to this arrangement about immigration. The other reason, which Bove said in his memo, was that the prior U.S. attorney, that's Adrian Williams, had either filed the case for partisan purpose, that is, to influence the election, or that Williams, after he resigned in December of 2024, mentioned the case kind of sideways on his own personal website, and that had prejudiced the jury. Neither one of these is true, even from it doesn't pass the smell test, but also Judge Ho has already ruled on whether Adrian Williams' website prejudiced the case. He said it clearly did not. And Adams was free to file a motion to dismiss for selective and vindictive prosecution, and he did not because that was too stupid. So, right. That ship has already sailed. The second reason that the case had to be dismissed is that it was, as he said, compromising Adams' ability to cooperate with the federal government on immigration issues. And so he instructed Sassoon to, with all haste, to ensure that Eric Adams' security clearance was restored. And, first of all, Danielle Sassoon, as the acting head of the Southern District of New York, didn't have control over the security clearance. The White House absolutely could have fixed that if they wanted to. They've certainly given security clearance to a bunch of, coders, like all of the Doge code bros without any difficulty. They could certainly have given it to Eric Adams. But also, it was kind of stunningly hypocritical for Bove to say that at the same time that the White House is yanking security clearance from all kinds of people whom it doesn't like. For instance, they've yanked security clearance from Manhattan District Attorney Alvin Bragg and from New York Attorney General Letitia James. So, don't be saying, oh, yeah, we need the mayor of New York to cooperate with us on immigration. At the same time, you're yanking security clearance from the other law enforcement officials in the city.
Yeah, those arguments were such obvious pretext, right? As Sassoon pointed out in her response letter to Bove, the question of whether somebody has seen a website is the classic thing that can be resolved on voir dire, right? Like you just ask the jurors, hey, did you see this on the website? And if they say yes, you strike them from the jury for cause, right? Problem solved. I want to add one last thing to conclude in this section that Akerman doesn't mention that I think is another possibility, and that is Judge Ho could tell the government, hey, I'm willing to grant your motion, but only if you dismiss with prejudice, right? To at least, it gives him a bigger carrot, but at least it gets rid of the stick. I don't know what your thoughts are on that, Liz.
Yeah, I don't really know what's going to happen. I don't think any of us knows how Judge Ho is going to handle this. But, to square that circle, dismissing it with prejudice would mean that they couldn't use this for corrupt purpose. And we've talked on this show a lot about how judges are kind of signaling to each other strategies for doing that, right? If you were talking about them running this play on other politicians, if Ho said at the outset, I'm going to let you do this, but I'm going to dismiss this case with prejudice, and he could do that. I think he could do it sua sponte. He doesn't have to get the government to buy in on it. He could dismiss the case with prejudice, and then maybe the next time they try and run this play, the next judge will dismiss with prejudice and will not allow them to corruptly wield the prosecutorial authority that way. That would certainly be an outcome I could live with.
Yeah. It does mean an extra windfall for, crooks, but so be it. Okay. We will be back with our last story after this final ad break.
And we are back. Okay, let's talk about the first, but clearly not the last, of the Trump executive order cases to land on the shadow docket at the Supreme Court.
Well, we think we reached the shadow docket, right? Like the government is circulating a copy of this filing, but that was last night. And as of this recording, 24 hours later, it's still not on the Supreme Court docket. Now, to be fair, right, today was President's Day, like that. There might be non-pretextual reasons for it, but like we don't have a filed copy.
Yeah. So this case is called Dellinger v. Bessent. It's currently in the U.S. District Court for the District of Columbia in front of Judge Amy Berman Jackson. We talked about it at length in the Patreon bonus in the last episode.
Yeah, and I want to be clear and signpost up front. There are two stories here, right? The first has to do with the merits of the case, which are more of a challenge. We're going to talk about it. The second has to do with whether the Supreme Court is going to once again craft special rules to benefit Donald Trump. That deals with the procedure. And with respect to that second issue, I want to say this. I think if the Supreme Court does that, and we're going to talk about what that means in a minute, that is absolutely an indication as to whether this court is going to stand up for the rule of law in any way, or whether they're going to capitulate and let Donald Trump get away with his fascist coup. And again, as of our record, that is still up in the air. So Liz, why don't you give us the background on the merits of the case itself?
Okie doke. So this one involves the Office of Special Counsel, OSC, which is an independent agency created by the Civil Service Reform Act of 1978 to protect civil service employees who, quote, blow the whistle on illegal or improper official conduct. Now, partly because it was designed to stick up for federal whistleblowers, the OSC is one of many executive branch agencies which Congress tried to shield from political pressure. So OSC is led by the special counsel who is, quote, appointed by the president by and with the advice and consent of the Senate to serve for a term of 5 years and may be removed by the president only for inefficiency, neglect of duty, or malfeasance in office. This is in contrast with the inspector generals we talked about earlier, who, they have a little bit of statutory protection, but that's not this.
Yeah, not removal for cause. And I should clarify as a matter of vocabulary that the special counsel and the office of special counsel that we're talking about in this case are entirely different from special counsels like Jack Smith and Robert Mueller that we've been talking about for years, even though they sound the same. I'm sorry, lawyers suck, right? This special counsel and the office of special counsel that's a permanent position and a permanent agency created by Congress to protect whistleblowers. So there's no like Eileen Cannon shenanigans going on here.
Not yet.
Yeah.
So the current special counsel of OSC is Hampton Dellinger. He was appointed by President Biden and sworn into office on March 6, 2024. So his 5-year term doesn't expire until 2029, another 4 years from now. But Trump fired him anyway without cause. And, it's not hard to see why Trump would want the chief legal officer protecting whistleblowers to disappear. Dellinger sued, seeking an injunction that he can't be fired. And note that he did not wait 3 weeks to do it. He more or less did it the next day. And in fact, he showed up at work and forced them to, frog march him out the door.
Yeah. And again, from Dellinger's perspective, the law protecting him is crystal clear. It is 5 U.S.C. Section 1211B. And Trump's argument is not, we did fire you for cause, you were inefficient, whatever. His argument is that the law is unconstitutional because you can't prevent the president from firing heads of executive branch agencies. And the basis for that argument is a case called Seila Law versus Consumer Financial Protection Bureau. We have talked about that a lot on the show before. That's the case that invalidated.
We're going to talk about it some more. I promise you.
Yeah. Although the Trump administration seems to think it's called Seila Law. It's not. Seila Law. Anyway, Seila Law struck down the legal protections for the director of the CFPB that said they could only be fired for cause. And so, and look, I think Seila Law was blatantly wrongly decided, right? It's, not going out on a huge limb there. So if you ask me, do I think the Roberts Court is going to jump in and extend Seila Law to include the Office of Special Counsel? I don't know, maybe, probably. The Roberts Court's pretty bad. But even if they do, even if you think that's where they're headed, and there are reasons to think maybe not, right? There are distinctions between the CFPB and the OSC. Lower courts still have to follow the law until the Supreme Court says otherwise, right? And okay, we will talk more about the merits of that argument if and when it arrives at the Supreme Court. But now I want to go back and talk about that second issue, procedure, because in my view, this is far more dangerous.
Right. So the first thing Judge Jackson did upon receiving that complaint was to issue a 3-day administrative stay so she could get a temporary restraining order on the calendar so she could hear arguments. The administrative stay required the Trump administration to unfire Dellinger and not fire him until after the hearing. Judge Jackson, like a bunch of her colleagues in D.C. and elsewhere, cited to that Supreme Court concurrence by Justice Amy Coney Barrett from U.S. v. Texas for the authority to issue administrative stays. Mostly administrative stays are an appellate remedy. They're not usually used by trial courts. But right now, as we said, as Judge Reyes said when she was yelling at Seth Waxman, the courts are just drowning under all of these cases. And sometimes you've got to just hold shit still until you can get the parties in for a hearing. And I think Judge Lauren Ali Khan in the U.S. District Court in D.C. was the first one to do this. And now all of these judges are doing it. They're saying, look, Justice Barrett said we can, and now we all are, and, live with it.
Yeah. And so, despite the fact that no one has ever done so before, Donald Trump immediately appealed that administrative stay. And I want to be clear, this is another thing he cannot do. We have talked about this on the show, right? The overwhelming majority of trial court rulings are not immediately appealable. You just have to live with them. In order to immediately appeal, you have to fall into one of these exceptions that are called interlocutory appeals. And administrative stays are not part of that exception.
Yeah. So unsurprisingly, the three-judge panel at the D.C. Circuit kicked Trump out of court and dismissed that appeal sua sponte, that is, on their own. The order said, it is ordered on the court's own motion that this appeal be dismissed for lack of jurisdiction. Appellants have not shown that the district court's order, which entered a 3-day administrative stay to afford time to consider appellee's motion for a temporary restraining order, had the effect of granting an injunction that is appealable under 28 U.S.C. 1292A1. So basically they said, this is not the kind of thing you can appeal, jackass. Go back to the trial judge. And Judge Amy Berman Jackson also thought that was bullshit. So during the pendency of this purported appeal, Judge Jackson held a hearing and granted the TRO. And then she, threw shade at the Trump administration when she ruled, because ordinarily an interlocutory appeal does divest the trial court of jurisdiction. But this was, but she said defendant's appeal of the administrative stay did not divest this court of jurisdiction to consider the instant motion. Only a non-frivolous appeal from the district court's order divests the district court of jurisdiction over those aspects of the case on appeal. A motion is frivolous when its disposition is obvious and the legal arguments are wholly without merit, which is judge talk for you never had an appeal, and any sane person knew that you never had an appeal, so I just pretended that you didn't because it was so frivolous and stupid. Don't you feel dumb?
I hope they did.
Yeah, well, probably not. Anyway, Judge Jackson granted the TRO, and second verse, same as the first, Trump immediately appealed that, even though a TRO is also not immediately appealable. And once again, the D.C. Circuit dismissed that appeal of the TRO. But this time, it was the same panel. It was Judge Gregory Katsas and Judges Florence Pan and Michelle Childs. Those latter two were Biden appointees. Katsas is a Trump appointee.
Yeah. Quick deep dive here, right? We have said that a temporary restraining order does not qualify for interlocutory relief. That's true. Even though a TRO is slightly longer than an administrative stay, TROs expire under the federal rules after 14 days. They can be renewed once, but that's it. And so it makes no sense to bring everything in the case to a halt and have the parties write briefs. If look like by the time you get there, the TRO would expire on its own anyway. Now, there are a few exceptions. We don't have to get into it because what Judge Katsas was interested in was not, does this case fit into those sort of corner cases? Katsas just said okay, he's the president. Every time the president can't fire somebody he wants to fire, that's not just irreparable harm, but super duper extra strength irreparable harm. And that's worrisome. It gave me really bad Trump v. US vibes.
Yeah, I just want to make that super clear what he was saying here. Katsas is saying, look, normal people don't get to appeal a TRO because normal people's concerns are normal people's concerns. But the president's concerns are the president's concerns under Article 2. And so they should be immediately appealable because he's so much more important than anyone else. And, the Constitution will feel sad if he doesn't get a special set of rules applied to him. And that's crazy, but also it sounds a lot like Trump v. US when the Supreme Court said, well, the president is different. He, no man is above the law, but also maybe the president is above the law. So here's what Katsas says in this case. The extraordinary character of the order issue here, which directs the president to recognize and work with an agency head whom he has already removed, warrants immediate appellate review. When it comes to judicial review, courts have long recognized the special status of the president. Have they? Is that a thing?
No. And as the majority points out in the same order, that argument assumes what the litigation is designed to contest, right? That Trump did indeed fire Dellinger, right? But the statute says, no, you didn't. You can't. And so really what Katsas's argument should say is the extraordinary character of the order here, is that it directs the president to recognize and work with the legal head of an executive branch agency that he would really, really like to remove, but can't. But I guess when you say it that way, it sounds pretty stupid.
Right. Well, then next, Katsas said, immunity considerations reinforce this conclusion. The judiciary must be restrained in order to protect the president, which the last I understood it was not actually the purpose of an immunity decision.
No. And what is astonishing to me is that these arguments continue to get briefed by Trump lawyers as separation of powers concerns, but they're not really about separating power. They're about unilaterally deferring to executive power, and like that's the opposite of separation of powers.
Right. Checks and balances exist to check, right? The Supreme Court isn't supposed to be a bolster for the executive branch or the judiciary writ large.
Yeah. So, okay. But despite Katsas's dissent that we've just spent some time on, Trump definitely lost at the D.C. Circuit. And so he did the same trick, right? He immediately appealed up to the Supreme Court. And that is, by the way, I think the real purpose of Katsas's dissent, right? It was to send up a trial balloon to the Supreme Court and say, hey guys, you gave Trump the entire universe last time. You could give him everything he wants again. And look, lest you think I'm being alarmist, I want to quote the argument that Trump's lawyers make in his petition for relief from the Supreme Court. They say, the United States thus respectfully requests that this court vacate the district court's order and end the practice whereby courts seize Article II powers for 2 weeks, yet disclaim the availability of any appellate review in the meantime. This court should not allow the judiciary to govern by temporary restraining order and supplant the political accountability the Constitution ordains.
Yeah, that is really such a wild inversion. For the Trump administration to accuse the courts of seizing Article II powers is very, it's ballsy considering that they're trying to seize the powers of Congress, right? They've unilaterally seized the power of the purse and said that it belongs to them and not Congress. And they're now staking claim to the right of the judiciary. I mean, as we discussed, like it was 1803, Marbury v. Madison. It is exclusively the province of the court to say what the law is, right? If the question here is it legal for the president to fire the special counsel when the law specifically says that it's not, like, whose job is that if not the courts? That's not the courts seizing a power of the, Article 2, the president. That's the courts exercising their obligation.
Yeah, that's exactly right. And I want to point out the perniciousness of how this is phrased, right? Because this special exception would only apply to Article 2 powers, right? Those are cases involving the president. And if the Supreme Court buys this argument, here's the practical consequence. That means going forward, every time a district court judge issues an administrative stay or a temporary restraining order or otherwise stands in the way of Donald Trump in any way, that will be immediately appealable all the way up to the Supreme Court. And that means, in my view, that the Trump administration will not even pretend to follow district court orders anymore, right? That they'll say, oh, yeah, you've issued a TRO or an admin stay, like, whatever, we're going to appeal. John Roberts is going to bail us out, and they'll keep doing what they do. It will be completely lawless. And I don't think I'm the only one who's worried about this, right? We have talked about State of New York v. Trump. That is the case pending before Judge McConnell in Rhode Island, brought by blue states, challenging the wildly illegal Trump executive order freezing federal funds. And what happened there was Judge McConnell issued a temporary restraining order, and then the plaintiff states came back to him the next day and said, we know you issued a restraining order, but the government still isn't giving us our money. Like, they seem to be violating it anyway. And so they filed this motion to enforce the TRO, which was basically like, will you please tell them to do what you told them to do? And Judge McConnell granted that motion to enforce. And what he said was, it is a basic proposition that all orders and judgments of courts must be complied with promptly. Put that in bold italics. Persons who make private determinations of the law and refuse to obey an order generally risk criminal contempt, even if the order is ultimately ruled incorrect. The orderly and expeditious administration of justice by the courts requires that an order issued by a court with jurisdiction over the subject matter and a person must be obeyed by the parties until it is reversed by orderly and proper proceedings. So in English, what Judge McConnell is saying is, look, I think I'm right, but even if I'm wrong, even if I'm later reversed by the First Circuit or the Supreme Court, you, Donald Trump, have to listen to me now. And if you don't, I can't put the president in jail, but like, I'm putting you on notice that your flunkies are risking criminal contempt for disobeying a court order, even if I'm later reversed.
Yeah. Okay, there will be so much more. We do not have a Patreon today because as of now, I still do not have power.
But we went
Just
extra
waiting.
long, so.
Yeah, well, and yet they keep sending me texts that say, "No power for you, ma'am," but we're working on it. Okay, God bless, and thank you to the linemen who are out there. I know that like the entire East Coast is one windstorm. All right, that's going to do it for us. We will be back on Thursday with written content, and we will be back on Friday with another show. Talk to you guys soon. See ya.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Ipsa Media, LLC, all rights reserved.